Hi, welcome back to Finally Revealed. In this episode, I want to talk about contracts and specifically the enforcement of contracts. A contract doesn't have to be in writing. However, there are certain situations when you want a written contract and when they have to be in writing. And I have some other videos, I'll put the link below, that cover those areas. In the situation of a written contract, the court, if a court is sought to enforce the contract, you go to court because someone doesn't perform the way you think they should, or someone thinks you didn't perform the way they think you should based upon what's in the contract. One of the parties may go to the court to enforce the contract and request the court order the performance that is missing. In order to evaluate and determine what the obligations are under the contract, the court is going to first read it. They're going to read it by the individual sections if there are headings. But there is usually, in an attorney-prepared contract, there's a section that says the headings don't determine or limit what the whole contract says. The headings are normally just to divide the different sections and make it organized and make sure things aren't missing. When a court interprets a contract, they read the entire contract together. If there are any sections that are illegal or go against the law, those can be disregarded. The court will then look at the rest of the contract, and if there is a question that they have or they need some clarity about a certain section or what is meant, they will look through the rest of the contract to give that questionable section meaning. So they look at the whole thing, and the general rule is that they're going to determine the meaning of the contract within the four corners of the contract. So they're not going to look outside or request any additional information or what you thought about it or what someone else thought about it. They're going to look at the words. So it's very important that the words in the contract say what the deal is. What you meant should be stated there. And that's why before you sign a contract, you really need to understand what those words mean, and you need to communicate with the party writing or modifying or helping you review the contract as to exactly what you expect, what you need, and what you want to be in that contract before you sign it. So within the four corners of the contract, the court is going to give meaning to the different sections and interpret it. Or if it goes to a jury trial, the jury is going to determine what that contract means within the four corners. Okay, unless in that contract you have waived a jury, which you should probably do. Then once the court has, or the jury has looked at the contract, if there is any section in there or provision that's important to the case that is capable of more than one meaning, both by looking at that particular section and the whole thing. So if there's something that is not clear or capable of more than one meaning, then you can bring in talks about what was supposed to be in there, discussions ahead of time, other correspondence, and things like that. But you can't count on going in and saying, I thought this is what we were doing, or they told me this is what we would be signing to interpret a contract, because a written contract, because if it's already written down, if it is clear as far as what's there and what you want to have happen or what someone else wants to have happen is not in there, it's not going to happen, and you can't count on it. So that is how the court interprets contracts. I hope this was helpful to you. If you have any questions, leave them below. I'm going to do some more on this series, so stay tuned for those. Give this a like if you learned something or if it was helpful, and subscribe to see the other videos. Thanks for watching. I'll see you next time.